Is there anyone? Hi. Hi. Is there anyone? Guys, आ जाओ live. Hello? Hello? Hi. Am I audible? Hi, आप important chapter का revision करा देना. Okay. Okay. मेरी आवाज़ आ रही है? Hi, Rahul. Hello? मेरी आवाज़ okay, good. चलिए let's start our revision, guys. I have already shared the study notes question which we are going to discuss. Okay, done. Okay. Now we are okay, Rahul. Thank you so much. Okay, and I already shared all of the study notes in my Telegram channel. If you have not downloaded yet, please go and download because we are going to start our class. Okay, so give me a second, guys. Okay, let's start with prevention of operation and mismanagement. Okay, first of all, we are going to read all of the provisions of the sections quickly and then we'll go for some of the question. कर दो ना, कहाँ लिंक प्रोवाइड करना है? मुझे लिंक नहीं मिली आपकी टेलीग्राम की. टेलीग्राम की लिंक आपको मेरे डिस्क्रिप्शन बॉक्स में मिलेगी, बायो में. आप वहाँ से जाइए और लिंक पे टच कीजिए, क्लिक कीजिए और वहाँ से आप टेलीग्राम चैनल में जा सकते हैं. ओके, so we are going to start the chapter prevention of operation and mismanagement. So first of all, we have to know what is the meaning of operation. Okay, so whatever is conducted, the conduct of the affair, just a second, guys. The conduct of the affair of the company can be said oppressive only when it is burdensome, harsh or wrongful. So there are three things which we have to write when we are quoting the answer, when we are answering. Okay, so that is burdensome, harsh and wrongful. Okay, and another thing is that we have to keep some more points while writing this operation में होता क्या क्या है. Violation of the condition of failure on which every shareholder who trusts his money to company is entitled to rely. There must be an element of lack of pity or fair dealing to the member in matter of his property right as a shareholder, whichever, whether the member is going in loss or something which is done against the members. So here the member can go against this thing which is known as oppressive, and there are so many other things, whether the loss incurred by the company comes in this term or not. If the company have not declared the dividend, whether that would be called oppressive and mismanagement of the company or not. So we will read everything in this sections and in this chapter. Okay, so number 4 section is 241, where the application to the tribunal for relief in case of operation. So when the company can claim, when there is a chances, then the oppressive में क्या क्या चीज़ें होते हैं, first we have to understand that. The oppressive, to claim the relief from the oppressive, one or more member who are eligible under 244. So 241 is saying that the members can go and claim. Okay, and the conditions are written in under section 244. Okay, but with that, what is this? When the member can go against this term, okay, when the affair of the company have been or are conducted in manner, there are 3 points which number first point is saying. Number first, when the company, the prejudicial to public interest, when number first the affair of the company are being or have been, ठीक है, are being or have been or are being conducted in a manner of prejudicial to public interest, prejudicial to the interest of the company, or prejudicial or oppressive to member making such application. So first says the affair of the company have been or are being conducted in such a manner, and there are 3 things which I saying. Or the second point says about the material change. Now we have to understand what is the meaning of material change. Material change says about the alteration of member, alteration of BOD, alteration of membership, ownership, and so on. Okay, so this is the major part where saying the company can claim the relief from oppressive where one or more member who are eligible as section 244, but everything of the condition is written in 241. So this was the application to the tribunal for the relief in case of oppressive. Itni baat hope so is clear to you. And apart from this, the central government can also apply the tribunal under chapter which 16. So there was a question being asked in MCQ, the central government may apply the application to tribunal under which chapter? Chapter number 16. So when is the central government can go for applying the application? Number first, there is only one point which says about the when the central government is of the opinion that the affair of the company are being conducted in prejudicial to the public interest. Okay, then only the central government can apply the application to the tribunal. So this was all about the section 241, where when the order to claim relief under from the oppressor the condition says about 3 things: affair of the company being conducted prejudicial to the public interest, company or the members. Okay, second, material change, and third is when the central government is of opinion that anything is done against the public interest. Okay, so this was all about this section 241. Okay, now what is section 244 saying? The right to apply under section 241. We already know the conditions of 241. Now we have to understand who are eligible to make the application. Again, 244 section is divided into 2 parts. Number first, where the members eligible to make the application are as follows. Number first, who is having the share capital, okay, where the company is having the share capital, and where the company is not having the share capital. In case where the company is having the share capital, 100 member, 1/10 of total number of member, or one or more member who is holding not less than 10% of issued share capital, whichever is less. Let me repeat, is 100 member, 1/10 of total number of member, or the one or more member who is holding not less than 10% of issued share capital of the company. And the second part says about what the company was not having share capital. In this case, 1/5 of total number of member can go, ठीक है, was eligible. And number third, always central government, ठीक है. So central government may itself make an application. If the central government is of opinion that the affair of the company are being conducted in a manner prejudicial to public interest. इतनी बात समझ में आ गई? हाँ जी. This was all about section 244. Okay, let's go for some of the cases where the members have applied for this. The Great Maratha. Hi. We are in the class. Okay, so let's discuss some of the case studies. Okay, now the member have applied the application to the tribunal. So whether they can withdraw this application, whether this is going to be valid if they withdraw the application, or the application will be continued. So here we are going to read this. So in this section, in the case, I'm just going to tell you a little bit about this. Okay, there was a case study which says about the Rajamundry Electric Supply Corporation versus Nageshwara Rao. In this case study, where the members withdrawn their consent. Now, whether this would affect the maintainability of application or not, once the member have applied for application, they cannot withdraw. If they want to withdraw, still the application would be in process. This is what this case study is saying. Rajamundry Electric Supply Corporation versus Nageshwara Rao. Okay. Second is about the relief for majority. Normally we all know minority gets relief, but is there any possibility that majority can also claim this? Yes, there is a case study which says about the Sindri Iron Foundry Private Limited versus yes, this is one case study, and second is Radhe Shyam Gupta versus Kamal Oil. ठीक है, so where the relief was given to the majority. So majority can be given when the conditions are satisfied. They will see whether actually the majority is harmed or something is done against majority member. In that case, they would also get the relief. Okay, now let's go for the other case studies where losses were incurred by the company. Now, is this going to amount to oppressive? No. In this case study, Ashoka Betelnut Company Private Limited versus MK Chandrakanta says, if the company is incurred loss and member filed an application, then whether this would be applied as oppressive? No. If the company is going through losses, they cannot be said that this is not going to be amount as oppressive. First point. Okay. The another point, another case study says about the non-declaration of dividend. What if the company was, yes, as the company was going in losses in the just above case study which I told you. Okay, if in continuation of that losses incurred by the company, that the company didn't declare the dividend, is this going to amount as oppressive? No, this is not going to amount as oppressive. This is what said in the case study of Thomas Watham versus Cottonard Rubber Company Limited. Okay, this was some of the case studies which we should keep in our mind. Let's go for section 242 and 243. Hi guys, if you are able to understand my language, hope so, hai na? Okay, if you have no notes, I have already given every note in my Telegram channel. You can download it. You'll get all subjects notes. Okay, and today right now we are going oppressive and mismanagement of the company. This is the first topic we are going for. Okay, so yes, let's go for section 242, which is about the power of tribunal and consequences of the termination and modification of certain agreement. Now, when just a second. When the tribunal can exercise this power, they are saying about number first again, when the company affair have been or are being conducted in such a manner which is prejudicial to the public interest, prejudicial to the interest of the company. This is going to be the third point, but with correlating, I am just telling you. And second, prejudicial to what? The oppressive to and oppressive to any member or members. So these are the 3 points which we already know. So this was what the tribunal may exercise the power vested in it, if it is in an opinion that the company affair have been or are being conducted in a manner of prejudicial to public interest, prejudicial to interest of the company, or prejudicial to oppressive or mismanagement of any member or members. Okay. Second again, the wind up of the company. So this is 2 point under section 242. Now what is going to be the tribunal power? The tribunal may purchase the share from any member, may reduce the share or restrict the transfer of share, restrict the allotment of share, termination, setting aside or modification of managing director, manager or any director of the company, may remove any director, managing director or manager, may recover any undue gain, or appoint any other person as the tribunal can remove. So they can the tribunal can also appoint, and with that imposition of cost. This was all about the power. But one thing, the company once receive the order from tribunal have to file the certificate copy to whom? To the registrar of the company. If the punishment for the contravention to this section is, if the company contravene any of thing under this section, then they would be imposed fine of 1 lakh to 25 lakh, and every officer would also be liable, okay, or the fine of 25,000 to 1 lakh and imposition of 6 months or both. So for the company, the fine is going to be 1 lakh to 25 lakh. You have to remember this point, guys. And for every officer, 25,000 to 1 lakh. Plus 6 months, one or both, either both. Okay, so this was the power. Now let's go for some of the consequences under the 243 section, where I have already discussed the power of the tribunal, and there was one point saying about the termination, modification or setting aside of managing director, manager or the director of the company, right? So this is going to be the consequences, continuation of that part, and this is going to be consequences of that particular point. Okay, so number first, vacation of the office of manager, managing director and director. Okay, from the order which from the order which is received by the tribunal. ठीक है? Okay. So no compensation. Are they going to get any compensation when they have to vacate the office? The manager, the managing director and director. No, they won't get any compensation where agreement which is related to termination, modification and set aside. Now are they going to appoint in the same company? No. For the similar appointment for 5 years in the company, they won't be appointed. Whom? The managing director, manager and the directors. Okay. So but there is one exception, that is saying about they have to, if the permission is taken from the tribunal, in that case definitely the appointment can be made possible. Okay. So there are some question, guys, so go for it. Question, okay, I have already given here. Lastly, I am also going to discuss some other questions, but this question is for you guys. Okay, so go for page number, let me say the last section of this chapter. Is this live will be available after this time? Hanji, this live will be available after this time. Okay, so you can also watch it later on when you get time. Okay. Okay, so let's start with section 245 section. Guys, let me tell you, this question was asked in one previous year question paper, okay, which is class action. So this is important, mark it important. This is of page number 16 of my notes. Okay, so where as I told you, the member can apply for oppressive and mismanagement of the company, right? Members can go under section कौन से में apply कर सकते हैं? 244. but ठीक है, and what were the conditions written in the section which is related to this? 241. okay, which is related to prejudicial to public interest company, है ना, affair of the companies, है ना, हाँ जी. Second was what? Any material change, and third was of the central government. Okay, but with that there is one more section saying about the class action, where the application is made by whom? By the member or a depositor on behalf, and remedies are also given here. Okay, and the question was simply asked, what is a class action and what are the remedies mentioned there. ठीक है, so ये बहुत ही simple और easy question था. Now the application may be made on the ground that the management and or conduct of affair of the company are being conducted in a manner of prejudicial to the public, to the interest of the company, or the prejudicial to the interest of its member or depositor. So the number of member and depositor are eligible to make application under section 245 are as follows. Number first, the member and the depositor. This is divided into two parts under section 245. Those who can apply for application to the tribunal. ठीक है, members and the depositor. Again, members are divided into two parts, where the company is having the share capital, where the company is not having the share capital. So thus the same point is in the company where is not having the share capital. Same point is as per the member wala 1/5 or total number of members. ठीक है, but what about the share capital, where the company is having the share capital? The conditions are different. ठीक है, earlier what we read 100 members, right? In case of members wala 244, 100 1/10 of total number member, or one or more member who is holding 10% of issued share capital at least, which means more than 10% of issued share capital. Okay, so in this case, in case of members, in case of having share capital, the company is having the share capital 100 member, 5% of total number of member. उसमें क्या था? 1/10 of total number of member. इसमें 5% of total number of member. Now the third point is about the member or a members holding, in case of listed company, at least 2% of the issued share capital, and in case of the unlisted company, at least 5% of issued share capital. इतनी बात समझ में आ गई? Hope so this point was clear. So yes, whichever is lower, they can apply either 100, 5% of total number of member, or member holding, in case of listed 2% of issued share at least. ठीक है, and in case of unlisted, that is going to be 5%. Very good. So this was all about this point. Let's go for the depositor case में. ठीक है, again for the depositor, 100 depositor or 5% of total number of depositor, or one or more depositor to whom the company owes 5% of the total deposits of the company. Okay, so whichever is less, they can apply for the tribunal application. ठीक है, so what are the remedies now? As I told you, simple question आ गया था. So this we should know what are the remedies. The tribunal is empowered to pass any of the following order: to restrain the company for committing any act which is ultra-wise the article or the memorandum of the company. Second, to restrain the company from committing breach of any provision. To declare any representation altering the memorandum or article of the company is going to be void. Okay. Hi Nazim, am I audible? Okay, I'm continuing. Okay, next, to restrain the company and its director from acting such a resolution. Guys, what's this all about? This is about the revision of corporate and economic law, and we are going for the prevention of operation and mismanagement of the company, and we are doing the last section of this topic, which is under section 245. Okay, you'll get all the notes in my telegram channel, and my telegram channel link is in my bio description. Okay, ठीक है. And yes, with this we are also going to discuss some of the questions from some we are going to refer some books question with scanner question. Okay, okay. So this was important, and this was asked in the previous year question paper as it is. Okay guys, so let's go for the other point. To restrain the company and its director from acting on such resolution. To restrain the company from taking any action or passed by which is to any resolution which is passed by the member, or to claim any damages, compensation or the demand. Okay, so this is the major part of this section guys. I've just read it out. Okay, क्योंकि important है. Now shall we go for some question guys? I have just shared, I guess, just taking classes, just taking before this classes, I've just shared some of the PDF in my telegram channel. So let's go for one question guys. Okay, this is, I'm going for case first. You'll get the PDF of this notes in my telegram channel guys. I just shared around 6:99 or 7 o'clock. I just shared one study module, study notes. Okay, so I'm going for case 1, where a group of shareholders consisting 25 members decided to file the petition before tribunal for relief against the operation and mismanagement by board of director of MS Fly by Night Operation Limited. The company has total 300 members, and the group of 25 members hold 1/10 of the total paid up share capital. ठीक है, अच्छा, this is about what, which section? Definitely it's going to be about 241 section, and with that 244. ठीक है, because eligibility was in 244 section, right? 100 member, 1/10 or one or more member holding 10% of the voting share, total number of members. ठीक है, so this was this part. So let's continue, where there was 300 member, and the group of the 25 member hold 1/10 of the total paid up share capital, accounting for the 15th of the issued share capital. Okay, so the main grievance of the group is that due to mismanagement by the board of director, the company is incurring losses, and the company has not declared any dividend. So as I told you, if the company is incurring the losses, ठीक है, whether it's going to amount as the oppressive or not, ठीक है, forcing. Now they are saying due to occurrence of losses, the company have not declared the dividend. But there is one thing they have mentioned: the company incurred the losses just because of what? Due to mismanagement of the board of director. Could you please share a screen? Actually, I don't know how to share the screen. Sorry, because I'm using two devices here. One is my mobile phone, where you can see my face, and the another is my tab. So I really don't know how to connect it. If you know, please let me know in the comment section, because I really don't have idea how to connect these two. Let me see, just a second guys. Okay, I'm just continuing guys. Okay, because I have no other option with me. I don't know how to share the screen. Okay, so yes, so this is what they are saying, whether this is going to amount as oppressive. Okay, let me continue reading guys. So they have not declared any dividend even when profit were available. नोट्स वहाँ देखो, मोबाइल से मैम को सुनते बेटर. हाँ, यस राहुल, थैंक यू. ठीक है. So yes, not declared any dividend even when the profit were available in the past years for the declaration of dividend. So let me tell you one thing. When I told you this is not going to amount as oppressive or not, if the company is incurring the loss, whether that would be amount as oppressive or not, no. ठीक है. But if they have not declared dividend, whether it's amount for oppressive or not, yes, again no. But due to the mismanagement of the company, the losses were incurred. Where is notes in my Telegram channel, guys. अच्छा देखो, open my Telegram channel, you'll get the link in my bios description. Wait, just a second. Hi Ritik. So I have just messaged in my Telegram channel. Okay, you'll get there. So shall I continue? Guys, I'm continuing because मुझे कोई reply नहीं आ रहा. Okay, so in this case, the question where we were discussing where the company, just because of companies, thank you ma'am, notes are so easy and understandable. Yesterday I scrolled randomly YouTube, then I got your channel, just I want to say you low, thank you so much Rahul. Okay, just पढ़ते रहो. Okay, so in this question they are simply saying the company incurred losses just because of mismanagement of the company. So is this going to amount as oppressive? Yes. Okay, so guys, let me read this answer which is just written below. Okay, as per section 244 of the Companies Act 2013, the case of company having a share capital member eligible to apply for operation and mismanagement shall be the lowest. Yes, which is 100 member. Okay Ritik, okay, which is 100 member, 1/10 of total number of member, or member holding not less than 1/10 of issued share capital of the company. Okay, so this is what we have to write in the beginning. Okay, when they have given us question, and if the question is relating to mismanagement, oppressive and all, so we have to relate it. First of all, the given problem relate to section 241. 241 में क्या क्या था, again you have to remember them guys, ठीक है, and which is to be read with 244 where the conditions for eligibility is written there. Okay, so this is the point. Okay, with that the condition is to be written. Let's go for the next page guys. Okay, the given case and analysis of this case where the applying the provision of section 244 to the given case, the eligibility shall be as below, as follows. Number first is about the 30 member irrespective of amount or percentage of the share held by them, or the second, one or more member holding 1/10 of issued share capital of the company. So in this case, a group of 25 member have made an application to the tribunal. Okay, the application are less than 30, as this was 1/10. 1/10 300 का 300 का 1/10 is going to be 30. But here the group of 25 member had made an application to tribunal, and also the application hold less than 1/10 of issued share capital which is given in the question. Okay, of the company. So thus the said group of shareholder does not meet any of the above eligibility criteria. This is clear, hope so. Then however the tribunal has discretionary power to weigh the eligibility. So this is the exceptional case where even though the eligibility criteria is not met by the member, the tribunal can waive off that criteria. Okay, so this is all about this case. Let's go for the third point in the continuation. In the present case, the only grievance for the member is that the company is incurring losses and the company had not declared any dividend in the past during the years where the profit were available for distribution of dividend. No other material has been produced before the tribunal to prove the operation and mismanagement. So what is going to be the conclusion here? Because number first thing, every time if you are going to tell this the crime happens, so the law is only going to see the proof है तो हाँ ठीक है, proof nahi hai to they are not going to entertain, even though they know just because of the mismanagement of the company, this was done because of mismanagement of the company. So what is going to be the conclusion here? The application made by the member does not meet the criteria requirement as contained in section 244 and therefore liable to reject it unless the tribunal waive the eligibility criteria requirement. Second, the members are not likely to succeed in getting relief from the tribunal since the allegation that company is incurring does not amount to oppressive or mismanagement as was held in the Ashoka Beetle Company Private Limited and versus M.K. Chandrakanta. Second, the allegation that company had not declared any dividend in the past during the years when the profit were available for the distribution of the dividend does not amount to oppressive and mismanagement here. Okay, so this was all about this part. So let's go for the next page, guys, where the question is related to depositor. Okay, I'm not going in depth, guys, so you have to solve this. This is related to 245 section. Okay, so you guys just solve it. Let's go for the other point, which is of the other question is of the scanner. Okay, PBX Limited is a company in which there are a shareholder of Bala who is director and also the legal representation of the deceased shareholder holding less than 1/10 of the issued share capital of the company made a petition to tribunal for a relief against operation and mismanagement. So first of all, the director is not going for the application here. The legal representation is going here because of the director, the deceased shareholder, as we all know. Okay, but the legal deceased shareholder is holding less than 1/10 of the share capital of the company. The deceased shareholder they are talking about. Okay, so now they are asking whether it's going to be eligible. So first question, in this question they are simply asking pehle ki legal representation can go for it or not. If yes, now the second point is that the deceased shareholder holding less than 10% of the 1/10 of the share capital of the company. Okay, so let's go for the answer, guys. According to section 244 of the Companies Act 2013. Okay, in the case of the company having share capital, the following member have the right to apply the tribunal under section 241. Not less than 100 member or 1/10 of the member issued share capital or what one or more member holding more than 10% of issued share capital. इतनी बात मुझे पता है. Okay, so what about the legal hire? Yes, legal hire of the deceased shareholder with minority status is entitled to file the petition. इतनी बात समझ में आ गई? हाँ जी. In the given case, there are 6 shareholders. As per the condition, 10% above 10% is going to be 10% of 6 is going to be what? Satisfy the condition. Here, I guess this is the different question I have taken. No, don't go for this part, guys. Okay. So in this case, if the person is having a less than 10% of issued share capital, then this cannot be done. Okay, because the criteria is not meeting here. I am CA finance student but still watching this video and will share this to my friends who are pursuing the course. Thank you so much, Ritik. Okay, so let's go for the next part, guys. You have to download the compromise and arrangement chapters note from my Telegram channel. Just go back to my Telegram channel. I'm again sharing my notes. Okay, you have to just download it. Okay, this. So shall we go for compromise, arrangement and amalgamation? Okay, I'm going with that. So when the compromise, arrangement and amalgamation is going to happen, okay, and who are the parties? Number first, the compromise and arrangement may be proposed between number first always company, but with whom? Company and creditors, company and members. Okay. Second, companies and class of members, class of creditors, or company and class of member. Okay, so with this, then application proposing and compromise and arrangement made to tribunal by whom now is going to be the next question. By the company, definitely by the member, by the creditor, by the official liquidator. Okay, so what are the disclosure along with the application is to be made? All the material fact which is related to the company is to be disclosed along with the documents, along with the application. And what are the material fact? the latest financial position of the company, the latest financial auditor report of the company, okay, and if any pendency of the investigation or proceeding against the company, then that is also to be attested with the application. Now what else? The reduction of share of the company, or if the company is gone through corporate debt reconstruction, that should also be attested. But with that, once this corporate debt reconstruction is done, the auditor's report is to be attested. Okay, so the report by the auditor, with that the guidelines specified by the RBI and valuation report of the registrar valuer. With this, the creditor's responsibility statement and safeguard for the protection of the other secured creditor and secured creditor. So let me tell you one more thing, because there is a lot about this section, guys. So let me tell you everything shortly. Okay, so compromise and arrangement is proposed between the company and the creditor, or the company or class of creditor, between the company again or the member, or company and class of member. And who can file the application? Definitely company, the members, the creditor and the liquidator, the official liquidator. And with that, they have to send the disclosure, the material fact, okay, the share capital, reduction of share capital, the corporate debt reconstruction in case, the report by auditors in case of corporate reconstruction, and with that the guidelines which is specified by the RBI and the valuation report by the registrar valuer. ठीक है, इतनी बात याद रखनी है. Let's go for the notice of meeting, where the meeting is proposed to be called in pursuance of the order by tribunal. Notice is given to all the creditors, all the members and the debenture holder. So the creditor, member and the debenture holder should receive the meeting notice, and with this notice all the documents should be sent to the statutory audit authority. And who are the statutory authority now? The central government, the income tax authority, the Reserve Bank of India, the Security Board of India, the registrar, the respective stock exchange, the official liquidator, or the competitive commission, or any other such other sectoral regulator. Now above authorities have the right to make their representation within 30 days. These authorities, which authority we are talking about? The central government, the income tax authority, the Reserve Bank of India, the registrar, the official liquidator, the competition commission, ठीक है, so the stock exchange and all, ठीक है, so they have the right to appoint the representative within 30 days once they receive the notice and documents. So with this, the company have to place the notice and documents on the website of the company, okay, and it is to be sent to the SEBI if the company is listed, and third, notice is to be published in the newspaper, okay. So this was the major part. Now this where we have seen that the compromise and arrangement is proposed between the company and member, the company and the creditor. But what if the tribunal decide to go for it, where the meeting of member is called by tribunal? So what is the other chances or the condition which they are talking about here? So in this case, with a meeting of member is called by the tribunal, it is to be approved by majority of member. Majority of member means more than 50% of member. So like, can I say it should be 51% or more? Okay? Yes, and that approved member should hold 3/4 of the value of shares. So the majority of members should hold 3/4 of value of share, then only this is going to be approved. इतनी बात समझ लेना, ठीक है, because there is question simply asking about this point. With the meeting of member is called by tribunal, what are the condition, whether this is going to be approved or not, ठीक है. So the members of the creditor not present in the meeting are not going to be considered here. Let's go for section 231. This is about the power of tribunal, where the power of tribunal is going to be supervise, direction, modification or winding up of the company. Okay, so let's go for the section 232. Okay, so section 232 says about the merger and amalgamation of the company. As per section 232, an application made to the tribunal under section 230 for the sanctioning of compromise or arrangement, it may be shown to tribunal. ठीक है, The question was asked from this topic, guys, so this is important, mark it is important. The compromise arrangement has been proposed for the purpose or often connected with a scheme for reconstruction or merger or amalgamation. So they are simply saying the compromise and arrangement which is proposed, which has been proposed for the purpose is for the connection with what? The reconstruction, the amalgamation or the merger of the company. Number first condition. Number second, the whole or any part of undertaking, the property and the liability. I am repeating it again. The whole or any part of undertaking, property and the liability of whom? Of the transferor company is to be transferred to whom? The transferee company. ठीक है? Whole or any part of undertaking, property, liability. Again, ठीक है, the whole or any part of undertaking, property and liability by whom? By the transfer company may be transferred to transferee company, and there would be more than one transferee company. Earlier it was one company, one transferee company. In the second point, of second point, ठीक है, so they are saying कि हो सकता है there would be other more than one transferee company. Okay, so this is about this point. Okay, let's go for some other points. They are saying circulation of certain documents by the company, the draft of the proposed term of the scheme. The draft scheme is to be adopted by the merging company's director. The first point. Then the confirmation copy of the draft scheme has to be filed with the registrar of the company. Second point. The share exchange ratio should be there. ठीक है, and with that a supplementary accounting statement. There is some condition, if it is required, the condition should fulfilled. Okay, so there are 4 points. The circulation of the certain documents by the company, draft scheme. ठीक है, draft scheme is to be what? The copy, the certification of copy of draft scheme is to be filled with the registrar, share exchange ratio and the supplementary accounting system. Once this part is done, filing of order of tribunal. Every company related to which the order is made by tribunal shall be filled a certified copy of the order of tribunal with the registrar within 30 days. Within 30 days of receipt of the certified copy of the order. Okay, so once this order is passed, it is to be filled with the registrar. Okay, filing of statement until scheme is completed. So filing of statement is to be done with whom? Is to be filed with the registrar. ठीक है, and it should be filed every year until the completion of scheme, and should be filed by whom? The chartered accountant who is in practice. ठीक है. Okay, statement shall be duly certified by whom? The chartered accountant in practice, the company secretary, the cost accountant in practice, and the company secretary who is in practice. Okay, so in the what is going to the punishment for the contravention in this case? Every transfer company, every transferee company going to be punishable, liable for punishment and fine. And the fine is going to be start from 1 lakh and can be extended up to 25 lakh, and for every officer imprisonment is up to 1 year, and with this fine or both, ठीक है, 1 year to 25 lakh, 1 lakh to 25. So for the transferor company or the transferee company, in case of contravention, punishment is going for 1 lakh. Initial, it's going to start from 1 lakh, can exceed up to 25 lakh. Again, for every officer, imprisonment is going to be 1 year. With that, the fine is going to be 1 lakh, 25 lakh तक extend हो सकता है. The other point is 233, which is again important, mark it important, guys. Merger or amalgamation of certain company. Okay, a scheme of merger or amalgamation between two or more company only if the company is the small company first. Second is about one company is holding company, another company is wholly owned subsidiary company, and the third, such class or classes company may be prescribed. Okay, so this is the criteria of the certain company under section 233. I am saying it's important. Okay, so in this case, the company, the transferor company and the transferee company have to issue the notice to whom? To the registrar, to the official liquidator. And within 30 days, once they receive, the registrar and the official liquidator receive the notice, they have the right, either they can suggest something, ठीक है, or they can object within 30 days. ठीक है, and if they have given any objection or suggestion that should be considered in the general meeting, and it should be approved by the members, and it should be only approved, it is going to be approved only if the member or class of member holding at least 90% of the total number of share vote is in favor. ओके इतनी बात समझ में आ गई. हाँ जी. नाउ द अदर पॉइंट इज दिस, एज आई टोल्ड यू, the registrar and the official liquidator have right to either they can oppose or give suggestion, right, within 30 days, and again that suggestion and the objection is to be considered by the company in the general meeting and approved by 90% of the members, right. Same thing, the scheme is to be approved by majority representing 9/10 in the value of creditors or the class of creditors, otherwise won't be. Yes, same thing. ठीक है. Now last, the company have to file the solvency with the registrar. ठीक है. And a filing of approved scheme is to be filed with. Once this every part is done, the transferee company have to file the copy of approved scheme with 3 authorities. Number 4 is the central government. ठीक है. Number 2 we all know registrar. Number 3 we know the official liquidator. So this was all about this section 233, and guys this is important, let me read it again. ठीक है. Where the merger of amalgamation of certain company, first the company is small company, second point is about the one company is holding and the another company is the wholly owned subsidiary, and third is such class which is prescribed. Hi Suresh. Okay. So issue of notice by whom the transferor company and the transferee company to whom the registrar and the official liquidator within 30 days they can object or they can give suggestion. ठीक है. If that is done by objection and suggestion given by both of them, that is to be considered. 90% ज़्यादा value by member, again 90% से ज़्यादा value of creditors. ठीक है, in favor. Okay. So solvency declaration is to be filed with registrar. This is important. Okay. What if no objection is made? Definitely the central government shall register the same. बात खत्म. Let's go for the section 234. Again question आया हुआ है, mark it's important. Merger or amalgamation of the company with the foreign company. So applicability where the company registered under section this act or the company is incorporated in the jurisdiction of the such countries which is notified by the central government. So in this case prior approval of the RBI is to be taken for the merger of the foreign company into companies registered under this act, for the merger of the company registered under this act into the foreign company. So what is the terms and condition here? The payment of consideration to the shareholder of merging company as per the scheme drawn up in such a purpose should be in cash, depository receipt or cash in depository, मतलब partly in cash or partly in depository receipt. Okay. Section 235. Let's go for section 235. With the power to acquire share of the shareholding is dissenting from scheme or contract approved by majority, where the transferor company is going to prepare the scheme or contract to whom? To the transferee company. Okay. This offer is this process is basically known the takeover. This offer is made to shareholder of another company to acquire their share. ठीक है. And the offer is going to remain open for the 4 months. Okay. Now approval of offer, where the notice is given by the transferee company to the descending shareholder and within 2 month expiry of the term of 4 month they have to reply. Okay. So descending shareholder मतलब क्या होता है? Descending shareholder is the one who have failed to refuse to transfer his shares of the company. So whether they are going to have some right, yes they are having the right, and that is the descending shareholder may apply may make the application to the tribunal that for the acquisition of share shall not be permitted. Okay. So when are the cases when the acquisition of share by the transferee company, ठीक है, where the no application is made by the descending shareholder to the tribunal within 1 month, or where the application is made by descending shareholder but the application is dismissed by the tribunal. So here the transfer company shall not entitled to acquire the share of the descending shareholder if the tribunal allows the application. Okay. So this was all about this section. Let's go for the minority shareholding 236, where the majority shareholder may give offer to buy the equity shares of the minority shareholders as per the price determined by whom. Again there was a question in MCQ. ठीक है. The price is going to be determined by the registered valuer. ठीक है, so this was the MCQ question in previous year question paper. ठीक है, so again I'm saying the majority shareholder may offer to buy the equity share of minority, and is the price is going to be determined by whom? By the valuation. It's going to be evaluated by the registered valuer. ठीक है, according to the prescribed rule. So the majority shareholder shall deposit the amount equal to the value of shares of the minimum share to the separate bank account. इतनी बात समझ लो. There are some cases where the situation where any minority shareholder fail to deliver the shares. Number 4, in case minority shareholder fail to make the physical delivery of shares with the time specified by the company which the shares are being transferred. In this case, the share certificate shall deem to be cancelled. But what about the situation where the shareholder has died or ceased to exist? In this case, the right of the such shareholder to sell his shareholding shall continue for period of 3 years from the date of acquisition of major shareholding. Okay. Third condition is about the situation where will shareholder holding 75% of more shareholding reach us understanding for the transfer at a higher price. In this case, the major shareholder shall share the additional compensation to receive by them with the minority shareholder on the pro rata basis. Okay. And the last situation where the majority shareholder failed to acquire the full purchase of the share of his minority. In this case, the residual minority equity shareholder has been delisted and the period of 1 year or the period specified in the regulation made by Security Exchange Board has elapsed. Okay, let's go for the another important section, which is section 237, and trust me guys, question आया है, बहुत बार आया है. So mark it important. 237, where the power of central government to provide for amalgamation of the companies in the public interest. Central government empowered to order to amalgamate to one or more company into a single company. But when the central government is going to order that? By issuing the official gadget. ठीक है, but in what case? When the central government is satisfied that such amalgamation is essential in the public interest. ठीक है, again central government can do by issuing the notification in the official gadget. Okay, so this part is important under section 237. So what are the conditions for making the order of amalgamation, guys? The central government shall send the draft copy to propose amalgamation to each of the companies, and the shareholder and creditor of the each company may give objection or suggestion within 2 months. Okay, the central government may modify the draft order it may deem fit. Okay, so there are some conditions which the company have to go through. The same interest and the same right of all the members and creditor of the transferor company is going to be transferred to the transferee company. First point. Same point, the member and creditor, what if they got less than his right or interest? ठीक है, in that case they would entitle for commission, the transferee company. ठीक है, what if they get less interest or right, they would be entitled for the compensation. Yes. And last, the copy of every order of amalgamation shall be laid before the House of Parliament. Okay, so let's go for the other section, registration of offer of the scheme involving the transfer of share, where a director of the transfer company shall prepare a circular. Number first point, that circular disclose the step where the cash will be available or not. All the steps should be mentioned there. Okay, and that circular is to be presented to the registrar of the company. Okay, but the registrar may refuse a reason to record in writing to registrar the circular where doesn't contain any proper information or contain information in manner likely to give a false impression, and the registrar refused to register the circular, he has communicated such a refusal within 30 days of the application. ठीक है, and whether the director can go for appeal against this? Yes, the director can go for appeal to the tribunal. And what if is there any the fault is of director? In that case, the penalty would be liable of 1 lakh. Is there now the section 239? Again, this is important section, guys, which is of preservation of book and paper of amalgamation company. Okay, for disposal of book and paper, the company have to take a prior permission by the central government. So what is that? This section is about the company cannot dispose any book and paper of amalgamated company. They have to preserve it, okay? But for doing that, they have to take the prior permission of central government. And what is that? The appointment of the person to examine the book. The CG may appoint a person to examine the book and a paper of a company before granting permission disposal of what? Of the book, of the promotion or the management of the company, the amalgamation, acquisition of shares. Okay, so this was all about this section. And section last is 240, liability of officer in respect of offences committed prior to merger and amalgamation. This is easy. So guys, again open the question series for this, okay, and just read it out. Amalgamation merger wala question. Okay, okay guys, you just, I'm going to close this live guys, take care, and I'm coming back, okay.